Boa tarde, senhoras e senhores. Peço, por favor, que tomem os seus lugares. Gostaria de convidar a mesa diretora deste evento, o excelentíssimo senhor desembargador federal Reis Fried, diretor do Centro Cultural da Justiça Federal, que hoje nos acolhe aqui tão bem. Por favor, desembargador Reis. Na sequência, convido também o nosso convidado neste evento, representando o Tribunal de Justiça do Rio de Janeiro, desembargador Caetano Fonseca, foi também diretor da Escola da Magistratura do Rio de Janeiro. Acho que é melhor aqui, porque ele deve usar aqui a sala, né? E vou falar em inglês, last but not least, né? Nosso convidado e palestrante desta tarde, professor Ian McDougall, que é vice-presidente executivo e conselheiro-geral da maior empresa de tecnologia do mundo, a LexisNexis. Sua aproximação com o direito e sua atuação no reforço da Rule of Law fizeram com que fosse escolhido membro do Board de Conselheiros da ONU. E convido, então, please, Mr. Ian McDougall. Eu passo a palavra agora ao nosso diretor do Centro Cultural para fazer uma saudação aos senhores.
Professor Ian McDougall, nosso querido desembargador, representando aqui o TJ, nos conhecemos hoje, mas é como se nós tivéssemos conhecido há mais de 50 anos, porque há coisas que a gente não consegue explicar na Terra. Nós tivemos aqui uma empatia tão grande, né, que talvez nós tivéssemos conhecido em momentos pretéritos. E, professor Ian McDougall, nós brasileiros sempre dissemos o seguinte, ele vai traduzir, que quando nós conhecemos alguém aqui no Brasil, nós agradecemos. E quando nós agradecemos aqui no Brasil, é um pouco diferente da América. Porque na América se fala thank you. E aqui nós falamos obrigado. E obrigado para nós significa que nós queremos uma obrigação para com a pessoa. Nós queremos uma vinculação com essa pessoa. Então, a partir desse momento, todos nós aqui, em sua maioria juízes, desembargadores, colegas e professores, que enfim, todos nós aqui em última análise somos, passamos então a estar vinculado com o senhor para lhe apoiar no que for possível e contar com o seu apoio também para nos ajudar e todos juntos fazermos realmente um mundo melhor.
And that's why everybody here, judges, lawyers, from this moment have a link with you, also to support you with what you need, and also to have your support to together make a better world.
Thank you, that's very kind.
Eu estou, na verdade, em sessão, preciso retornar à minha sessão, mas eu fiz questão de vir aqui prestigiar todos os senhores, o professor e o desembargador em especial, porque achei que era importante registrar a nossa presença, Fabrício, a presença da Justiça Federal, da Justiça Estadual, do Poder Judiciário e do Brasil nesse importante evento.
He's actually in the middle of a judgment, but he thought it was very important to stop this judgment, to come here and reinforce the importance of your presence here to the judiciary power of Brazil, federal justice and state justice too.
Amazing, thank you.
Vou pedir 1000 desculpas pela minha ausência, porque eu preciso realmente voltar à sessão, mas como eu disse, eu precisei vir, porque eu acho que é importante que nós nos prestigiemos a todos nós em prol de uma justiça melhor, não só no Brasil, mas em todo o mundo. Eu sei que o professor Ian está com esse compromisso de fazer uma justiça melhor. Muito obrigado.
He apologized, he has to come back to the judgment, but he reinforced the purpose of making a better justice for the whole world, not only for Brazil, and your presence here is important to that.
E eu vou pedir então licença ao professor, ao desembargador e a todos presentes por essa minha saída, mas é por motivos plenamente justificados. Thank you, professor.
Thank you.
Senta aqui, Fabrício, por favor,
E agradecendo as palavras do desembargador Reis, que acompanho plenamente, transmito desde logo, claro, ao momento mais esperado da tarde, que é a palestra do professor Ian. Ian, are you going to speak in English? Okay, a palestra será em inglês, tá? So you can start.
Okay, thank you. It's difficult to follow an honour like that, but let me give it a try. And also, as a former advocate, standing in a courtroom always excites me still, so thank you. I am pleased, honoured, I appreciate the opportunity to introduce to you the subject of the rule of law. And why do I say introduce? Because in a room full of lawyers, everyone would think, well, you know, we're all supportive of the rule of law and we know what that means. But it amazes me that the rule of law is not taught in law schools. Law is taught in law schools, but the rule of law as a subject isn't taught in law schools. My little personal mission, and I travel the world talking about this subject, is to try and change that in some way. So, and I do love talking about the law, I should say that, you know, and when you're in the middle of cases, in the middle of practice, when judges are in the middle of doing their judicial work, it's easy just to get into a rhythm and you just do what you have to do day after day. But let me give you a little reminder of why many people come into the profession. The law is one of the most fantastic and wondrous achievements of human civilization, and we need to remember that. If we follow it's a purely philosophical concept, don't forget, by which all people can live their lives based on reason, reasonableness, and consent, even if all of those things are instinctive. So I also want to emphasize today that the rule of law as a subject, it delivers peace, prosperity, and social advancement wherever it is strong. And I have some evidence to be able to put before you on that. I also want to make a little comment about the difference between justice and the rule of law. Again, they are two different concepts. Justice is an entire subject, all of its own, and there are many aspects to it. The theory of natural justice, utilitarian approaches, social contract arguments, all of these things. But just for today's purposes, I'm going to give you a simple rule, which is that justice is what is delivered by the rule of law. And the one justice depends upon the rule of law for its delivery. So I'm just going to briefly talk to you today about the origins of the rule of law, because the history is important. I'm making a case for the universal application of the rule of law, no matter what society you live in, no matter what system of government you Then I'm going to define what I mean by the rule of law, so that we know a lawyer wouldn't be a lawyer if he didn't try to define something. And then I want to talk about the economic impacts of the rule of law. And this, again, is very important, particularly to this audience who is able to advocate for this, not just because we're all lawyers talking about things we like, but because this has a benefit to society that you can measure. And I think that's an important element of what we need to do. In other words, I'm making a business case for the rule of law. I'm going to show you that it benefits your pocket as well as your morality. So when I started this campaign, which we call Business for the Rule of Law in my company, I'm very proud to say it eventually became a joint project with the United Nations. And I have the good fortune to sit on 2 United Nations committees that deal with this subject. But when it started, I first assumed everyone would immediately know what I'm talking about. That was wrong. And secondly, that lawyers everywhere would understand the same thing when I said the rule of law. And that was wrong too. And even, when you say the rule of law to an audience of lawyers, I have had people in audiences say to me, I don't understand the problem. We have laws. Yeah? And I'm going to answer that point by explaining the difference between the rule of law, which is what we're talking about, and rule by law, which is something different again. Let me talk very briefly about the origins of the rule of law. It's very important. There are some interesting little pictures around here that I will be referring to in a minute. Because the origins of the concept of the rule of law is not some kind of Renaissance Western power type thing. It dates far back. I can take you back to the Code of Hammurabi, for example, around 1760 BC. And this is one of the first examples of codified law presented to the public and applying to the acts of the ruler. The king of Babylon, Hammurabi, stated clearly, these rules apply to me too. That's an interesting concept as well. In the Arab world, throughout the Middle Ages, Islamic law scholarship embraced the notion of the rule of law. If you think about it, again, if you are an Islamic leader, you follow the same rules under Islamic law as everybody else. And principles including Confucianism and various other things also have these elements to them. If I can just quote from Plato, going all the way back to ancient Athens. Plato said in his book called Laws, where the law is subject to some other authority and has none of its own, the collapse of the state is not far off. But if the law is the master of government, then the situation is full of promise. The problem is with tyranny, and I mean elected tyranny as well as unelected tyranny, is that it always leads to arbitrary power, unfairness, eventually to corruption, and then eventually to injustice and abuse. And it's worth noting here that it's not just the way you exercise power that causes the problem, it is the unwillingness to give power up that is also a major problem. For example, in a country in Africa recently, the president had the constitution altered to enable him, it is usually a him, by the way, to stay in power indefinitely. This is a direct threat to all kinds of good governance principles. In India, the rule of law can go back to Upanishad in the early era of Hindu writing. Upanishad said, the law is the king of kings, and it's more powerful and higher than kings, and there's nothing higher than the law. And so then we have an interesting development which is known as Magna Carta. Magna Carta was the first known document imposed upon a king by a group of his subjects. They were the early aristocracy. This is important as well. They imposed this document, abstract concept, on a king to limit his powers and protect their rights by law. This is a very important development. And the influence of that charter is still felt now beyond that very windy field in southern England. For example, the due process clause of the US Constitution, which is Section 1 of the 14th Amendment to the US Constitution, expressly lifts almost word for word the section of due process from Magna Carta. Okay, why have I gone through this historical run-through, you may be thinking? What has this got to do with it? I'm trying to show you that the history is long, that the history can be traced back through many parts of the world. It isn't just one area of the world. I have an expression I use. This is not the West telling the rest how to behave. Yeah? This is a concept which has, through history, universal application. So let me now talk about the definition. I'm taking those elements out of history from the different parts of the world to produce a modern definition. There are many definitions. Everyone who writes about the rule of law seems to produce their own definition. At the United Nations, the rule of law appeared in the preamble to the Universal Declaration of Human Rights in 1948. There's a report of the Secretary General called The Rule of Law and Transnational Justice in Conflict and Post-Conflict Societies. You will hear my criticism of the UN in just a minute, but that gives you a flavor of what I mean. The main problem with these definitions is that they are awful. They are complex, they have clauses and subclauses, and they go on for page after page after page. Now, I understand that. The United Nations has 190 different countries, and everything it does has to be the result of a compromise. So I get that. But that does not help communication, conveying of the message easily to everybody who is not a lawyer. And that's, fortunately, I'm not bound by the UN constraints, and so I'm able to say these things. The UN issued reports in 2002 and 2004, and they talk about all kinds of things, quality of legislation and procedural transparency, and the list goes on and on and on. Even each time the United Nations produces a document, they come up with another definition of it. So this is the difficulty that we face. It's why it's important to not just say the rule of law. It's important to say, this is what I mean by the rule of law. Now let's discuss this. In 2005, the International Bar Association produced a report as well, which was about a resolution that they had produced on the rule of law. To show you the problem that I'm trying to express, let me read to you, word for word, the resolution that the IBA came up with. Bear with me, because I need a deep breath for this. It says, an independent, impartial judiciary, the presumption of innocence, the right to a fair and public trial, a rational, proportionate approach to punishment, a strong and independent legal profession, strict protection and confidential communications. I can't get through it all. It goes on. It's a long paragraph. Now, all of those things sound very reasonable. But remember, I'm in search of a universal principle. I'm in search of a set of principles where no country can say, that is not how we work. Right? That is not something that could work in our country for cultural or political or whatever the reason might be. Because if I take some of the IBA's examples there, let's take, for example, a public trial. Sounds good, doesn't it? But what about when there are national security implications and the information would cause harm to national security? Should there be a public trial? Okay, the fact that we can debate that issue means it's not a universal application, I suggest. What about proportionate punishment? What does proportionate punishment mean? That to me sounds like a political judgment, a judgment of populism, a judgment of do we believe in hanging or do we not believe in hanging, and things like this. These are not universals, and I could go on. So I'm now going to take all of this down to some very simple concepts that the history of the subject shows us are consistent no matter where in the world we go. And remember, I'm trying to get the widest possible adoption of this, yeah? The best understandable, the easiest way to understand it. Has to be understandable, has to be universal, and it should not be founded on one region's philosophy or society as much as possible. I have 4 principles I can extract from the history and from the universality. Let me go through them for you. The first one, everybody should be treated the same under the law. Now, you might have picked up that concept a minute ago when I said that the Hammurabi king said that he would be treated the same under the law. The fact that this is very important has a number of benefits. The law is applied to everyone in the same way. That's the first principle. The second principle, that the process must be administered by an impartial and independent judiciary. That means judges who have no interest in which side wins. They have nothing personally to gain by the outcome, and they are not compelled by outside pressure to come to a specific decision. They decided on the basis of the law and on the facts. Now, a subset of this might be, for example, the fight against corruption and the fight against political interference in the judiciary. Anyone who has seen recently the United States trying to appoint a Supreme Court judge knows exactly that this is not the way to adhere to the rule of law. And I say that to American audiences as well as to others. The third principle is that the law should be properly published and accessible. You have to know what the law is. If you as a population do not have the ability to know what the law is, you can't demand its protection. And finally, the final element is remedy. You must have access to remedy your grievance. If I say in circumstances of equality, you can see how the 4 principles are interlinked. But basically the remedy point is logic. If you can't have your grievance remedied